Now it is time for discussion. So we're going to have two discussants on this panel. First is Judge Cabello, and then Professor Kim, who is, I believe, on the podium in Seoul. What I suggest is that I will first give the floor to Professor Cabello and then to Professor Kim. And once we have their comments, we'll open the floor for reactions by the speakers. So Judge Cabello, you've got the floor for 10 minutes or so.
Thank you, Professor Bodeau-Livinec. Dear colleagues, members of this panel, ladies and gentlemen, first of all, I would like to express my thanks to the organizer of this conference for inviting me to participate in it. It is an honor to me to have an opportunity to take the floor in such an important event. The two main challenges facing humanity in this time of history are the risk of a nuclear war, the total and final war, and the degradation of the planet's environment to a point when human life will not be sustainable anymore. The solution of this first challenge is to build a solid peace, and that of the second is to take the necessary measures to prevent and reduce as soon as possible all human activities that are transforming our nature to the point that it will not be able to sustain our life anymore. Both types of actions require not only our individual collaboration, but the effective and continuous cooperation of all human beings. This brief consideration gives us an idea of how broad in content the term cooperation could be, as it could encompass practically all the peaceful activities carried out by the international community's actors. Among them, what they are now doing in the oceans has a paramount importance and gives us full assurance on how essential is the main topic to be developed by this conference, cooperation and marine environment protection. Within this large topic, I was invited to discuss the three first panelists' interventions on how the duty to cooperate, as formulated expressly or implicitly in various articles of the United Nations Convention on the Law of the Sea, has been interpreted and applied by the International Tribunal on the Law of the Sea, Judge Kulyk, or how this duty, within the terms expressed in the Convention, have a role in the specific field of the protection of the marine environment and the protection and conservation of the biological diversity beyond the marine zones under national jurisdiction, Professor Oral, or in the particular geographical framework of semi-UNCLOS seas, Professor Lee. This is, of course, a narrow consideration of the duty to cooperate that can actually span many other areas of the activity exercised by the states in the oceans, some of which were dealt with directly by ICLOS, as Judge Kulyk has widely explained, like fisheries, pollution by hazardous materials, seabed activities, or activities that could jeopardize the outcome of any maritime delimitation claim. However, it still remains to be considered other possible expressions of the duty to cooperate, as was also mentioned by Professor Lee, by instance, in relation with the exercise of the rights of the landlocked or geographical disadvantaged countries, the necessary cooperation for the delimitation of the new ocean zones, such as the EEZ or the continental shelf, the vast field of navigation activities, or the prevention of the worst effects of the oceanic level rise as a consequence of the melting of the ocean polar caps and glaciers. Of course, any academic activity has to have a limit in its scope in order to offer effective results, and we cannot pretend in the case of this conference to go beyond what has been established in our program. Most of the panelists have approached the duty to cooperate from the point of view of their content, but we should also consider it from the point of view of those subjected to those obligations, in the widest meaning of both expressions. In this other context, it's only natural that most of the attention should be concentrated on the obligations of the most important subjects in the international legal order, the states. However, while there is no doubt in the Convention that international organizations are entitled to rights and duties of cooperation, both by demanding or providing it, we should also consider the situation of the natural and juridical persons. We could mention an example, Article 153 of the Convention, that in its paragraph 2 and 3 established that the exploration and exploitation of the resources in the area could be carried out in association with the authority, also by state enterprise or natural and juridical persons. And that in those cases, the plan of work shall, in accordance with Annex 3, Article 3, be in the form of a contract. We are here, without any doubt, in my opinion, confronting a case of cooperative effort between the authority and those persons, whose details should be clearly enumerated in a written agreement that take the forms of a contract. Even more, in the case where there is a conflict on the interpretation or application of the contractual terms or on acts or omissions of a party to the contracts, they can have recourse to the civil dispute chamber. And there is still a vast area of discussion that remains open in this matter. Professor Oral's paper is an effective contribution to a better understanding of the current negotiations of a new legal instrument that will codify existing rules or introduce new ones for the conservation and sustainable use of the biological resources existing in the oceans beyond national jurisdiction, that is to say, in the high seas and the area. If we take into consideration in conjunction what is also sustained by Professor Lee regarding the gaps that he perceives exist regarding the intent and requirement of the Convention in matter of cooperation, we totally agree that the present negotiations of a new agreement can help to fill the voids existing in the Convention in that particular field. However, as the negotiated solution to the imprecisions of the Convention, be it in a general agreement or in a regional or sub-regional setting that is seen what Professor Lee's preferred option, could be long in coming, we shouldn't leave aside any of the offered options, to which I would like to add also the recourse of an advisory opinion of the judicial body. In particular, as Judge Kulyk already mentioned, of the International Tribunal on the Law of the Sea, whose opinion has been at the basis, for example, of the regional agreement on fisheries concluded by a certain number of states in Northwest Africa. Professor Lee gives also us interesting insights on the nature of this duty by stressing two aspects of that cooperation. One, that it could contain not only an obligation of conduct, but it could also one of results. And second, that any form of cooperation cannot be fulfilled by a one-time act, but implies in many instances the existence of a continuous process whose scope and procedures must be duly agreed by the involved parties. However, the specific features of the cooperative process require will depend on the nature of the challenge the parties are facing. As a matter of fact, it's not the same to react to an event that already have taken place, like an oil spill in the EEZ or a coastal state by a ship carrying the flag of another state that requires quick actions from both sides to reduce the damages produced by the accident. Then to agree on permanent measures that could prevent those accidents never to happen. In the first case, the action in involved parties' action is put in results, while in the second case, it is in a consistent and permanent conduct. The content of the panelist intervention and this consideration only outline the importance of the cooperation effort and the need to make all involved actions clearly mandatory in order to achieve results that can no longer be postponed. Thank you very much.
Thank you very much, Judge Cabello. I think you made a very important points on the very nature of the obligation to cooperate and also its extension to other actors than the state parties to the convention themselves, the authority and also private parties. And I think that's a very relevant issue. Before I give the floor to the speakers, I should give it to the second discussant, Professor Kim, Hyun Kim, whom I believe is, I think she's preparing here. She's in Seoul at the Marriott Hotel. And I give you the floor, Hyun Kim. C'est à vous.
Thank you, Chairperson. It is wonderful to meet my friend, Professor Bodeau-Livinec again in this conference following last year. Good afternoon. My name is Hyun Kim from Yonsei University. First of all, let me express my deep gratitude to the organizers of this conference for inviting me as a discussant. COVID-19 makes it difficult for some distinguished participants to be here in person. However, I would like to think in a positive way during such a difficult time. We have a big online audience due to the live dissemination of this conference. This dissemination is meaningful and timely because our topic, marine environmental protection, needs all states and all people's attention and efforts. Therefore, I'm very pleased to be one of the participants in this endeavor to engage people's attention. Particularly, the first session of topic, the duty to cooperate, is one of the most important issues from an environmental perspective. As the three speakers pointed out, it is necessary to take into account all relevant provisions of UNCLOS in order to apprehend the contents of the duty to cooperate. For example, according to Article 1, Paragraph 1 of the Convention, pollution of a marine environment extends to include even activities on land if they result or are likely to result in deleterious effects to marine environment. Therefore, states parties to the convention are obligated to cooperate with other states when they launch projects or activities on land with such effects. As Chair's Arbitral Tribunal indicated, in accordance with the convention, states must not control activities that cause harmful consequences to the marine environment, but they must also take measures to conserve and preserve ecosystems. In this sense, the convention calls for more active conservation and preservation beyond simply responding to harmful consequences. Such a high requirement for marine environmental protection would have a consequence of strengthening the duty to cooperate as well. All of the three speakers gave very insightful presentations, which pointed out different aspects of the duty to cooperate. The first speaker, Ambassador Kulyk, gave a presentation about ICLOS' contribution to clarifying the duty to cooperate in marine environmental protection. I am grateful to the ambassador for sharing his experience in the tribunal with us. I agree with his argument that the duty to cooperate under the convention has two facets. that is, positive and negative requirements. It is also notable that the duty to cooperate must be implemented not only on international level, but also at the national level. The ambassador also stressed procedural obligations. I found this point particularly relevant because the international courts and tribunals have recently dealt with these procedural obligations in environmental disputes. An example is the obligation to conduct environmental impact assessment. Meanwhile, my question addressed to the ambassador concerns provisional measures before ICLOS as a tool to protect marine environment. The ambassador presented Mox plant case as an example. In this case, ICLOS did not accept Ireland's request for provisional measures. Nevertheless, the tribunal ordered Ireland and the UK to cooperate. Moreover, the tribunal did not mention Article 197 of UNCLOS concerning the duty to cooperate when ordering this measure. One question that I would like to raise here is the tribunal's specific criteria or threshold for prescribing measures for cooperation when conditions for provisional measures under Article 290, paragraph 5 are not fulfilled. It is not easy to identify this in the text of the tribunal's order, which is usually relatively brief. I would be grateful if the ambassador could provide some indications. Moving on to the second presentation, it is a great pleasure to meet Director Oral here. Next week in a seminar, I will give a presentation about the ILC study group's paper on sea level rise that Director Oral co-authored. Today's presentation stressed that the duty to cooperate for BBNJ exists not only under Part 12, but also under other parts such as Part 13 and 14 under UNCLOS. The director also pointed out that the BBNJ agreement is an implementing agreement of UNCLOS on the basis of the duty to cooperate. I agree with the view. However, I'd like to ask Director Ora to clarify the relationship between UNCLOS and its implementing agreement. How far can this BBNJ implementing agreement go beyond the convention? Some states have concerns that the new implementing agreement may jeopardize what was agreed under the UNCLOS. To address these concerns, Article 4, Paragraph 4 was included in the revised draft text of BBNJ. This provision states, I quote, "The legal status of non-parties to UNCLOS or any other related agreements with regard to those instruments is not affected by this agreement." End of quotation. I would be very interested in Director Ora's opinion about the meaning of implementing agreement. I think the term implementing has its limits in relation to UNCLOS. Finally, I would like to make comments about Professor Seok-Woo Lee's presentation. His presentation reminds me of the late ICLOS Judge Chun-Ho Bak's lecture course that I took at a graduate school about 15 years ago. George Park emphasizes the meanings of shall and should under UNCLOS in his first lecture on the law of the sea. Thanks to Professor Lee's presentation, I came to know that Article 123 is elaborated in an ambiguous manner. I also agree with his suggestion for contextual interpretation of the duty to cooperate under UNCLOS. However, I wonder whether this final suggestion, actually he briefly mentioned in the conclusion in the slide, I wonder whether his final suggestion about the amendment to UNCLOS is a feasible solution to clarify obligations under the UNCLOS. It may be difficult to reach an agreement for amendment considering amendment procedures under Article 312. I would like to hear Professor Lee's further opinion about this. It was a great pleasure to listen to the three speakers' contributions to share my observations with them. Thank you for your attention.
Thank you very much, Jung, for this very clear comments. I think you have given us some work to do. We have 15 minutes also. So who wants to react first? Is that Judge Kulyk wants to make some comments on the questions raised by the discussants?
Yeah, thank you. Thank you. And first, let me express my gratitude and thanks to other speakers and to discutants. It was really very interesting to listen to their contribution. Plenty of interesting and thought-provoking sometimes ideas. Taking into account the time, I'll try to be brief in responding to the question. Primarily, that my understanding of the question is that tribunals, what is the criteria of tribunals prescribing provisional measures when conditions are not fulfilled? Short answer is not possible. But the only condition the tribunal prescribes provisional measures only when the conditions of Article 290 actually are met. I think both cases which were mentioned, Max Planck and land reclamations, the tribunal specifically considered and take a decision whether those conditions are met. And they are primarily two. Those provisional measures were, those proceedings were actually based on the provision of paragraph 5, meaning that the tribunal was considering provisional measures pending the constitution of the arbitral tribunals. And they're based on the condition, based on the provisional of the conventions are two conditions. That prima facie, the tribunal considers that tribunal which to be constituted would have jurisdiction, and that the urgency of the situation so requires the prescription of the provisional measures. If you read the orders in both of those cases, the tribunal on both cases take a positive decision that prima facie it considered that the tribunal would have the jurisdiction, and that the urgency of the situation, and I don't want now to discuss what is the urgency in the meaning of the tribunal, it will take another panel probably, but that in the criteria and in the practice, that the urgency are actually met in both of that case. Later on, availing itself of this of the right of the tribunal of prescribed provisional measures other than the parties required, or not necessarily the same, only that the tribunal considered that the measures, including this cooperation, or as I mentioned in land reclamation case, the report on the infilling works, which could be considered also something similar to the environmental impact assessment, would be necessary, as well as other measures beyond cooperation would be necessary to prescribe, to preserve the rights of the party to that dispute. So, as I briefly, that tribunal always first considered that conditions for the prescription of the provisional measures are met, and only under that conditions it prescribes its provisional measures. Thank you.
Thank you very much, Judge Kulyk. I think I agree with you. And also, I was going to react after your own presentation that there is, of course, also, I don't know whether this is really well, it's going to be provocative what I'm saying, but, and I know it, but I use the Zoom protection in a way because I am talking to judges here, but I don't know whether there is a duty to cooperate, but maybe a incentive for cooperation among international courts and tribunals, even arbitral tribunals involved in these issues, and they are not discussing and solving these issues seldomly. The regime of UNCLOS, in a way, intends some kind of cooperation between the different kind of courts and tribunals which the party states may actually choose at some point. And there is a need for dialogue, which I think exists in practice. But this is a provocative comment. Thank you once again. Nilüfer, so I apologize, just colleagues. Nilüfer, your reaction to the discussant's point.
Yeah, thank you so much. And I want to just compliment Professor Cabello and Professor Kim for their excellent comments and really giving an opportunity to think also beyond the immediate I think questions that our presentations were directed towards. Now, Professor Kim, I have to say I'm very curious about your presentation on the ILC study group paper, so I'd love to hear more about that. Now, as to your questions, very good questions. First, whether the BBNJ agreement risks going beyond the convention. I have to say that the convention, and we can debate whether but it's typically characterized as a framework, constitutional, meaning it's not the final word. And we know that because we have the 1995 Fish-Stocks Agreement, which is an implementing agreement, and it certainly does go beyond the convention, adopting principles such as precaution that were not in the original convention. So we have to think of the Law of the Sea Convention as a dynamic, and the limits are placed by the negotiating process. And that's why we have these types of intergovernmental conferences, and at the end, consensus hopefully emerges. So I would not take a narrow view of the contours of the Law of the Sea Convention. And also the draft Article 4, Paragraph 4, it's pretty well what's in the Fish-Stocks Agreement as well. And so it's really to incentivize non-parties to the Law of the Sea Convention to join it. And we know, for example, in the Fish-Stocks Agreement, the United States is a party to it, but not to the Law of the Sea Convention. Now, your so a meaning of implementing agreement is, I mean, we don't have a technical meaning, but it's important because we need to be able to, and I think the situation, I'll focus really on the high seas. That's an area where there are gaps. And we know now, since 1982, much has changed. Climate change, for example, it doesn't directly, there's not an express reference to it. But does that mean that the Law of the Sea Convention cannot entail taking measures to address ocean acidification, ocean warming, the coral reefs? If we take a very limited view, which I think someone mentioned the definition of pollution actually would, in my view, entail climate change impacts, it would would actually undermine Article 192, which is probably one of the best articles there is for protection of the marine environment. I really can only say that the negotiators of Part 12 back in the late 70s, really, and when they adopted in 1982, it's remarkable. So we have to take a dynamic view of it, and an implementing agreement is the way to do that. So I won't go on because I know we're limited in time, but I hope I've answered some of your questions at least. So thank you.
Well, I must say thank you, Nilüfer. I must say I strongly support what you just say, and even broader, the duty to cooperate is a very good vaccine or vaccine. I don't know how you say that in English, against the risk of fragmentation of international law, and the need to think the regime out of the box in a way. And the climate change issue is, of course, obvious. So I can only support what you just say, very humbly and modestly, of course. Professor Lee, I think it's your turn to react to what has been said earlier for the few minutes we have.
Okay, thank you. As I mentioned in my presentation, thinking about the gravity of the actions and inactions of each state parties of the convention can take. For example, we can advise the state parties, you should not to do. You should not hamper or jeopardize the current situation or worse. However, it is quite difficult to advise, for example, certain governments, you should cooperate in some of the issues if, considering the, comparing the community interest and individual state interest is coping it. For example, we discussed the matter, Professor Kim and the Nilüfer is discussed the matter of the climate change of the sea level rise, and that the community interest is getting bigger and bigger in vis-a-vis the individual state's interest. Then we are eager to, or we can emphasize to our state members to recommend that we have to think about this preservation or protection of the body environment in that direction. So together with those to gravity, what happened in actual scene, and it is very good things from my own perspective is that the international judicial bodies right now provide us the very clear direction to say that states has the obligation or the duty to cooperate each other and based on the convention. The issues is that the convention, as I mentioned in my presentation, can be interpreted very diverse way, and how that the different interpretation application can be the makeup is largely two-way. And these days, personally, I involved the editorial work of some of the journals working on the ocean land policy. And the number of papers the submits to us is increased in terms of amendment or the fourth United Nations Convention on Law of the Sea. Although the many papers are dealing with the amendments, they emphasize that, in particular, the dispute settlement mechanism and the obligation rights of the coastal state, in particular, military activities are easy. Some of the the gray area we face in these days. However, the clarity enhance the clarity of the convention through the amendments, arguments or the suggestion getting higher and higher means that there is someday we have to hear that what we need for the convention or legal order of the ocean. So, but how this can be done, as Professor Kim mentioned, that there is also limitation. We know indeed, and that in a sense that I don't like to say that about judicial activism to interpret or apply the terms derived from the convention is much very important to go with that the trend. So I have to say that the judicial role and function of the judicial bodies, including tribunal and the courts, when they're dealing with the duty to cooperate, is very much important. However, if that the judicial activism or judicial interpretation show that enough, then I think if the state parties can go with the limitation of the individual state interests, then it is a time to think about some of the issues put together as a general theme. And the issues is that looking at I'll be very brief, looking at the step practice indeed, I don't know how many states indeed take it very seriously to cooperate in their decision-making policy when they're dealing with the neighboring states, in particular competing territorial or the maritime claims. So that the degree of each state parties to accommodate that the arguments of the duty to cooperate is, I think, a key cornerstone while we discuss the matter of we go to the first amendments on what other direction we have to go. So thinking about the step practice in this direction is very much important in this regard. So thank you.
Thank you very much, Seok-Woo, and also thank you. Sorry to have rushed a little bit, but we are running out of time, and I appreciate that. You mentioned both the need for states to consider the duty to cooperate when they have competing claims, but you also refrain from mentioning any state, which I find, of course, very wise. With this, I think we have to close the session now. We have many open questions. Judge Cabello mentioned the duty to cooperate as also as an obligation of result, which I find very interesting, and there is some possibility to consider the responsibility for the breach of the duty to cooperate. So we have a lot to do. That's maybe another meeting of the case for another year, and that's good to know. We are still thinking of the future. I want to thank everyone, the panelists, the speakers, the discussants, but also the organizers of the conference, Mrs. Shaw, who have been so helpful in helping us doing this Zoom meeting. I think in the program it's indicated coffee break. So coffee break works for me because it's, as I said, morning in France. But for you, it may be afternoon tea break or even whiskey break. Why not? I don't know. So I just wish you a good day or a good evening and enjoy the break. Thank you again to all speakers and discussants.
Thank you so much, Professor Livinec, for wonderfully moderating session 1. Also to all the discussants and speakers of session 1 for sharing their knowledges and ideas and opinions.